hard dispute, hey, this isn't my phone. Um, Even if he's saying it's my phone, he can't now dispute what's on the phone because he's inherently tied to the phone because it was his thumbprint that opened it. And that conveys to everybody, this is my phone. I'm in control of it. I can unlock it. And everything on it is mine.
In some ways, this technological world that we live in is a new frontier. But in some ways, we have to draw reference or analogy to what has existed before. And so I was trying to do that when I was thinking about this case. I was thinking about a blood draw. Because in those instances, it's not information that otherwise law enforcement would have available to them. It's, you're not going to agree that your DNA is a match, or at least a statistically significant match or correlation, but that is something that we have allowed.
I think the difference is you're taking a physical, what I'll call a physical characteristic, whether or not it's fingerprint, your blood for DNA, or even putting somebody in a lineup. But just giving somebody your blood doesn't implicate you. It's when they take that blood, DNA type it, and compare it to what they have. Here, I apologize, I'm going to keep doing that. Here, automatically opening that phone ties it to you and incriminates you because of what's on it. So I think there's...
But similarly, it's through extraction. It's, it's that information was made available once the phone was open. So once the blood was drawn, then that phone was taken somewhere where they could get that location data.
Yeah, but by opening it, you're automatically conveying, this is mine. This is my phone. Everything on it is mine, under my control, and I can't run away from that without anything else. So I think it's different in that regard because you're not saying, this is your blood. We compared it to the blood we found at the scene, and it was a match. You're stuck with that phone by opening it with your biometric data. And I don't think there's that second step. You're not taking just the physical characteristics of a person and comparing it to somebody else. You're taking those biometric data to basically authenticate that phone and point that phone to my client as his and under his control. I think that's the difference that I see.
Does it matter what the data is that is extracted?
I don't believe it does, because I think the problem is you're authenticating that phone. You're saying, this is my phone, just by putting your fingerprint on it to open it. This is my phone, and everything on it is mine. A couple of the cases that I've cited talk about requiring production of documents and just how producing these documents is a violation of the Fifth Amendment. And that's what we have here, just admitting basically the existence. And when you put your thumb on the phone, as I said, you can't run away from that. Everybody has a phone now. Everybody knows what that means. Everybody knows that's your phone. Everything on it is you. It's your life on that phone. So we believe it goes beyond just giving a physical characteristic. It authenticates that phone, ties it to the client. In that regard, it does violate, we believe, his Fifth Amendment right.
Does it matter that the other thing that I've thought about is that this location data would be available potentially through other means? Like it's possible that you could subpoena the provider. It's possible if the parameters are there to have a geofence warrant that allows people to see who was in the vicinity at the time, or at least what phone numbers were in the vicinity at the time. Does that matter?
I don't think it matters for a couple reasons. Number one is state never argued that. And I know I'm arguing preservation here. But number two, even if you get it from AT&T or whoever, I still think that is categorically different than if you get it off a phone this person has opened. If you get it off his phone, Again, it goes back to, it is tying everything on that phone to the defendant without having to go a roundabout way where, well, how accurate is AT&T's records? How accurate is their technology? I don't know. But if it's on my phone, I'm stuck with it. And I can't challenge it. It's self-authenticating when I open up the phone. Everything on it is tied to me. So I think it goes beyond just, hey, you can get it somewhere else, so what's the point? Here, you're also authenticating that information because the person opened the phone himself.
I'd like to redirect you for just a second on prosecutorial error.
Okay.
Okay, so talk to me about harmless error on this case. So let's assume for a second that the errors you allege are in fact errors. Why aren't those errors harmless?
They are not harmless because when you look at the burden we're talking about here, the burden is on the state to show that these errors did not contribute to the verdict. And they have to show that beyond a reasonable doubt. There's no real possibility they contributed to the verdict. And here, those errors, I believe, did. They told the jury what to think of the evidence. Hey, we know it's him. On the most contentious issue at trial, which was identity. So they told them, we know it's him. Even if they pointed to the evidence, the state is then putting the government behind that evidence. Hey, trust us. We know, we've got this evidence. We know this is true and accurate. We know it's him. So they're putting the scales on tipping the scales to their favor on the evidence. Then they're also telling the jury what to think of him. He's a predator. He's a danger. That's what this court found in Maven. That is loaded language with the underlying current of, hey, he's a danger. You need to get him off the street. And we believe that that contributed to the verdict here. And I'm going to emphasize the standard because standard is not, was there overwhelming evidence? The standard is not, would they have convicted anyway? The standard is whether or not it contributed to the verdict the jury gave. We believe those were inflammatory comments. Those altered how the jury would have viewed the evidence, and they did contribute to that verdict of guilt. So we don't believe just arguing overwhelming evidence is enough. And here we have, there were different defenses depending on the incident, but certainly what the state did is brought it all together and say, we know what the evidence is. And by the way, he's a predator, so you need to get him off the street. That's why we don't believe it can be viewed as harmless. And we would ask this court to reverse and remand for the reasons we said in our brief.
Any other questions from the panel? Thank you very much.
Thank you.
Counsel.
It please the court, Kendall Kaut for plaintiff appellee. I'll go in the same order as opposing counsel, but I'm happy to answer any questions, obviously, as this panel may have them. Pretty clearly, the Kansas Supreme Court has interpreted KSA 60-404 to require a contemporaneous objection for a motion to suppress or a motion in limine. Even if you can make a very textual reading of the statute, say, hey, I don't think those words are there. We believe the words should have to be there for the objection. There has been no sign that the Kansas Supreme Court is departing from its prior precedent. Obviously, I believe Chief Judge Warner, when you alluded to that and said, well, our reviewing court has given its rulings, there's no evidence from a deviation. And I think Mr. Mahari is probably setting that up for, if it reaches the next level, maybe argue that he'd like to see 404 changed a little bit. But because of those prior rulings, we don't believe there's a way around it, except maybe his claims where he says on, making sure I have the statute correctly, 223603, which is the state's right to an interlocutory appeal. However, as we've pointed out in our brief, just because the state can only interlock an appeal if the judge rules against the state at the district court level before trial, does not mean the change that Mr. Mahari is asking for on behalf of Mr. Elliott would obviate the issue he talks about. So the example here would be, let's say this goes to trial, contemporaneous objection happens by the defense, judge says, I changed my mind, you've convinced me, or something else has come out at trial to change how I view this evidence, or I think the officer's testimony is slightly different than I thought, did some more research, really all the reasons we look at for why we like a contemporaneous objection. Well, if that happens, and suddenly the judge changes her mind at trial, the state can't interlock that. So the defense still can make its contemporaneous objection, but the state doesn't get its interlocutory appeal, as we know, because jeopardy's attached and the state can't appeal it. So when we look at, could this be a way around it? Maybe some equity that could be a concern. I certainly appreciate Elliott's side bringing this up as maybe a way to get around 404 and argue this can be a different Venn diagram outside of the intersection of prior Supreme Court precedent. But ultimately, I just don't think that theory achieves its aim or has the solid foundational basis to be something to get to that path.
Counsel, Mr. Meharry had pointed out that there is Kansas Supreme Court precedent that doesn't require contemporaneous objection under 404 in instances where there is a bench trial. I mean, does that open the door?
So Chief Judge Warner, one, I don't believe it does, just to answer your question directly. Two, there is some case law, both from panels of this court and other case law out there that says even in stipulated facts trials, you should still object at that level. And even if I'm wrong on those first two questions, I mean, I think State versus Richard, where the Kansas Supreme Court said at 300 can 715, a majority of this court believes that a request for reconsideration of the district court's order on the suppression motion must be effected through a contemporaneous objection during the trial in order to preserve an appeal during the original ruling. So to answer that question directly, Chief Judge Warner, even if that is the case, that, hey, some exceptions have been recognized, we've chipped away at it, we still think that foundation remains, even if the hammer's been taken to part of it. What Mr. Meharry is asking for, we think, is too broad of a hammer being taken to that boulder that we believe still remains. If there are no additional questions on preservation, I will turn to the merits argument if this court decides to reach on that. I would first note that on the merits, our Kansas Supreme Court seems to really strongly desire to not reach the merits anytime this issue comes up. I was at Raising Cane's for lunch, and in kind of the same way when I go to Cane's, I have a strong desire to never get the coleslaw and get the extra toast. I think that same ideology reigns for how our Supreme Court deals with this issue. And I bring this up because in State versus Cherry, and another case I brought up, obviously even going back to 2010, they'll even reference going back to 2010. Well, a lot of ground's been plowed in this area, but we're just going to go to harmless right away. And I can respect that because when I was at the Supreme Court a couple of years ago, we ended up getting into an argument about whether an IRS case from the 1920s about compelled disclosure occurred, and there was its own independent doctrine for disclosure. So Chief Judge Warner, with what you've asked, I agree that it's like blood. It's like a thumbprint's more like that. It's like giving fingerprints. That's good enough for us. But I think the fact that our Supreme Court has been as reluctant as I can remember to address an issue that keeps coming up on other grounds is also probably a pretty good sign if there were ever a case to relax the contemporaneous objection rule. When Detective Sterling testified not once, not twice, but was called 3 separate times by the state to tell a trial story so it could be told, hey, here's the GPS data we got when Holly was the victim. Here's the GPS data we got when Anna was the victim. And here's the GPS data we got when Nancy was the victim. The fact that defense counsel never objected on those 3 instances and how reluctant our Supreme Court has been to address the merits, to me speaks to maybe why this wouldn't be the best time to say the contemporaneous objection rule should go away.
And let's say that we disagree, right? But we go to the breadth of information that is on a cell phone. Like here it was location data, and maybe that data would have been available elsewhere. But I just think of all of the information, and I'd like to think that I don't engage in a lot of nefarious activity, but I think of all of the information that is available on my cell phone. There's maybe there's journal information, there are communications, there's location information, but there's also banking information. I mean, it's a long list of information that is available through a thumbprint. Does that give you pause?
It would give me pause, Chief Judge Warner, but I believe the Fourth Amendment protections that attach are really where the protections for an individual and their phone exist. So in this instance, when Judge Sutherland provides that search warrant to say, we can get the contents of your phone because there's probable cause you were at those locations, that's where that protection still exists. Same way for search warrants in all of those line of cases from Birchfield, Rice, Neese. Really, we're looking at the Fourth Amendment for a blood draw for somebody to say, we protect your body. We don't want a needle to go into you. But once the blood comes out, that's viewed differently. So for me, the distinction I would draw is, yes, I think cell phones certainly are owed protection. Similar deal, Chief Judge Warner. I also think I'm doing the right thing when I'm using my phone. But obviously, I got a lot of stuff on my phone. I Who knows what's going on at any one date and time if someone pulls out a text, which I could understand even the most law-abiding citizen would be bothered by. But I think because of that Fourth Amendment protection, because judges would still have to issue a search warrant to get into the contents of that phone, I think that deals with our Fifth Amendment concerns that we have in much the same way that our Fourth Amendment concerns with getting blood from someone are dealt with by a search warrant being required, but the blood itself being viewed differently under the Fifth Amendment. So
But the blood has particular uses. We wouldn't allow someone to ask a defendant and compel an answer about communications that person had with another, or their banking practices, or in like a case that involved that kind of question, or where they were at a particular time. That's what the Fifth Amendment protects. Doesn't this seem to fall within that sphere?
I think that obviously with courts disagreeing on it, I don't think it's outside of the Overton window, Chief Judge Warner, to make those arguments. However, we believe the correct view within that Overton window would be to say those are not testimonial communications and that the protections would exist on the Fourth Amendment realm. We view, because the Fourth Amendment and what search warrant would be granted would necessarily be limited in scope to comply with that particularity requirement, we think that would obviate the concerns about police are in my phone, they searched everything, they went back to 2019, found something nefarious in my phone, now I'm in trouble and arrested. When the reality is if a judge gave a search warrant going all the way back to 2019 with no basis for probable cause, that would be checked under the Fourth Amendment. And so we think that's where the jurisprudence in America and under our Constitution can check those privacy interests we obviously cherish as Americans.
So let's stop and take a look at the blood draw, the example then under the Fifth Amendment. So someone takes the blood of a defendant. The defendant is not doing anything. They are standing there, sitting there, and a tech is withdrawing their blood. When you compare a defendant's actions to this case, where a defendant is entering a code or a thumbprint, that's different because the defendant is the one taking the action. Does that make a difference in whether or not this was testimonial?
For our purposes, we don't believe it does. Judge Bolton Fleming, I could understand a court saying, there are a million distinctions you can make between a thumbprint, a passcode in and of itself could be a difference. And I could see a court saying, whether it be this panel or Kansas Supreme Court or a federal court, hey, a thumbprint is different because it's just asking something you have, much like fingerprinting at the station. That's okay. But to ask someone to give a passcode is more akin to asking someone to give a passcode to a safe. And some courts federally have drawn that distinction between providing a key is different than actually asking what is your passcode to unlock the safe. And so I think my answers on that would fall back ultimately to answer your question. We feel like a thumbprint is sufficient because it's like grabbing your arm and just taking an appendage that exists naturally, if that were the dividing line. But I think because of how complex this can get, that's why we would probably ask this panel to take the lead that our Kansas Supreme Court has given us for 16 years and just say, why don't you preserve it if you'd like it? Or it's pretty harmless in a case with such overwhelming evidence. Although I'm happy to continue discussing the merits, and I know we could discuss this for hours, certainly, I will turn to the questions that Judge Bolton Fleming had about if there is a presumption about error, would it be harmless? I will first turn, because Mr. Mahari had made arguments about how should this court view those two instances of predator. The seminal, really Kansas case is that Mabin case from 2000. We think there are several distinctions. First, the Mabin panel just decided to say, well, we agree with the Washington line of cases as opposed to other lines of cases that say you just shouldn't ever call the defendant a predator. We think 26 years later, this court should disagree with that panel and say there are some instances where it's okay. In Mabin, that panel said most of the time it's not okay. Mabin was a robbery where the defendant put his hand over the victim. That is certainly distinct from when someone over the course of less than a week in Shawnee, Kansas, breaks into three women's homes and attempts to rape them, and in one instance actually does rape someone. That is a predator. And in kind of the similar vein to how our Supreme Court has reiterated in the context of presenting gruesome images. And when defense attorneys object, they say, well, gruesome crimes will lead to gruesome photos. When you try and rape three different women in 5 days and commit aggravated burglary in the course of three different counts of aggravated criminal sodomy as an attempted crime and a count of rape, you are a predator. Is it better to call someone a rapist than a predator? I'm not sure. They both seem pretty awful. But ultimately, it would have been fair to call Mr. Elliott a rapist because that's what he is. It'd be.
Well, it might not have been because that's what the state was trying to prove, right? That's the problem, is that it's about the state's burden and what the state is trying to prove. And on the one hand, as Maven points out, it's inflammatory language. And then also it's presuming the outcome that the jury is ultimately vested with deciding.
I think in some instances, Chief Judge Warner, it could. I respect if you disagree with me on predator, because I think ultimately we survive harmlessness. But I think when the state's arguing, the evidence has shown that the defendant is a rapist because count one's elements are, maybe puts the instruction up, goes through the elements for rape. I think that would be a fair comment within the wide latitude that a prosecutor is allowed. So I think there'd be some instances. I would agree. Sometimes maybe not. Maybe my original statement was a little too broad, but I think sometimes it could happen. I also can respect, though, and I'll just turn to harmlessness if there are no more questions on that. But ultimately, in this case,
Before you turn to harmlessness, let's talk about the phrase broke into their homes and shattered the safety and sanctity of those homes. Talk to me about that language.
sure. So Judge Bolton Fleming, our viewpoint would be that's within the picturesque speak that is allowed to be used because that's what happened. I certainly understand if someone just said, the evidence has shown he broke into Anna's home. The evidence has shown he broke into Nancy's home. The evidence has shown he broke into Holly's home. But I think picturesque speak allowed the prosecutor to properly, in this case, say, this did taint the sanctity of their homes and bodies. These were women that were at home in Shawnee, Kansas. These were women that certainly did not ask for Mr. Elliott to break into their homes. These were certainly women that did not ask for him to come into their bed, threaten that he had a gun, use inflammatory and insensitive language continuously, hold them down. So we believe that that should be within the wide latitude in a case like this that is so gruesome with 3 separate victims.
But could that language be reasonably interpreted by the jury to be a call to protect victims, a call to act? That's my concern, I guess, is when the prosecutor said shattered the safety and sanctity of those homes, what he's really saying is, jury, you need to protect these victims. And that's concerning to me.
Understand if that's concerning to you. I think the distinction we would draw is because it says because it's tied to the sanctity of what happened to them. That is not that broader call to action, which is sometimes the distinction between when it goes too far and when it's not. So that's the line we would ask this court to draw. But if this panel is uncomfortable with it, we're also comfortable resting on harmlessness. But I think that's where we would probably draw the line to say, look, is this picturesque? Yes. If you feel it becomes too picturesque to become inflammatory, we're comfortable resting on harmlessness too, ultimately. Because as mentioned, any one of these 3 attacks, because of how closely they're tied together, proves the others pretty well. And kind of the same way, if this were a 455 case, it'd be pretty hard for the defendant to stand up and argue these aren't very similar crimes in terms of how the break-ins occur. DNA is left at every scene, sometimes in the sextillions. I couldn't tell you how many zeros that is, but it seems pretty high to me. We have latent fingerprints. We have a cell phone left at the last location. For purposes of harmlessness, we would consider the GPS evidence. All of those things together ultimately provide overwhelming evidence in this case that, look, looking across a 4-day trial, maybe the prosecutor went a little too wide in a few instances for this panel, but ultimately with how strong this evidence was, that didn't contribute to the verdict. It was Mr. Elliott's own decisions, his own actions, the DNA he left behind, his thumbprints, and what he did on those nights in Shawnee, Kansas that caused the jury to reach the right verdict and find him guilty.
Other questions? All right.
Thank you.
Thank you, counsel. Mr. Meharry, you have 3 minutes.
Thank you. Just a couple points with regard to the first issue. It was mentioned that Kansas Supreme Court hasn't addressed this issue and apparently is trying to avoid it. I think that gives reason why this court should. There is a split out there amongst the states, amongst federal circuits on whether or not forcing somebody to open an electronic device with biometric data violates the Fifth Amendment. There's a split. There's no guidance in Kansas for district courts to look to. So I think that should be a reason why this court does address it. So it can give that guidance so we can get some case law on this. And certainly if this court decides it, you can always force the Supreme Court's hand, I guess, but
Not always, counsel.
you can always hope. But that would be a reason for this court to address the issue as well, to give that guidance to district courts below, because right now they're looking at a C going both ways and pretty evenly split. So guidance.
But if we can't reach this because of 6404, why would the Supreme Court even take up the merits if we aren't following their precedent?
You're asking me to contemplate their thought process. Your Honor, I think.
Welcome to our world.
Yeah. I think what this court has to do is look at this case, look at how it played out, and determine whether or not what was required under 404 was met. And if it was, which I argue it is, this court should address it, even if this court thinks, well, maybe the Supreme Court's going to disagree with us. This issue was properly teed up for the district court to decide it, and it did. And it's a purely legal question for this court. And that's why it should be addressed by this court. In addition, as I said, to give guidance to district courts below. The other thing I wanted to mention dealt with, there was some discussion about the Fourth Amendment, whether or not those protections come into play. I would say they do not. And the reason why I say that, and I was trying to think of the case because it's my case, and I believe it's State v. Voley out of the Kansas Supreme Court. And in that case below, they had a search warrant for my client's phone. And the wording was exceedingly broad. And the detective on the stand said, yeah, I could search anything and everything on that phone. That was upheld. Search was fine. So to think that Fourth Amendment's going to come in and say, hey, you can't look at that, I don't think that's the case. There's a Fifth Amendment violation here that contributed to the verdict. And I'll repeat the standard for harmlessness again. Did the misstatements by the prosecutors in closing arguments, improper statements, did what we would argue inadmissible evidence contribute to the verdict? We would argue certainly in both cases they did. And that's why we believe reversal is warranted. Thank you.
Thank you, counsel. Thank you very much to all counsel. We'll take this matter under advisement. We appreciate your very interesting and well articulated arguments, and we'll get an answer to you as soon as we're able.